7 minutes after 10, I'm Sizwe Mpofu-Walsh, and it is a tremendous honor now to be joined by a judicial titan, a fierce humanitarian, an exalted South African hero, but most important of all, a beautiful and dazzlingly fantastic godfather. Justice Edwin Cameron, thank you so much for joining us for this first interview since your retirement from the Constitutional Court.
What a pleasure and honor, Sis, to be interviewed by the best interviewer and the best godson in the world.
It's so fantastic to have you here. Everybody is so excited. All my producers were just in a state of euphoria. And, you know, so much has been said about your life. So much has been written about your life. And your life journey has been so incredible that in many ways there hasn't been as much public focus on your actual judicial career. And that's really what I want to talk about today. Your judicial career, a sterling judicial career lasting 25 years. And I wanted to ask to go back to that moment in 1994 when you made the decision, because you could have done many things, to go into judicial life and were appointed. What was going through your mind when you realized that you were going to embark on this journey to become a judge?
Well, it was an exciting moment, Sis, when Justice Minister Dalla Omar, who himself had been a struggle lawyer in the 1980s and was appointed to the cabinet by President Mandela in April, May 1994, when he called me and he said, "We want you to chair a commission into apartheid arms deals, and we're going to appoint you an acting judge to chair the commission." So it was quite a thrill. And of course, I had a high view of the position of judge and what judges could do, even though the apartheid judiciary had everything but covered itself in glory, because it supported apartheid for the most part, with some very wonderful exceptions. So it was quite a thrill.
I can only imagine. And having thought about that moment at the beginning of your career, what was the moment at the end of your career, just a few days ago, like when that 25-year journey came full circle and you're able to look back on those moments?
I said on Tuesday morning in court, and I still feel 48 hours later, an enormous gratitude, Sis. Obviously, a gratitude to be alive 22 years after starting antiretroviral therapies, when many of your listeners, I think almost every family and every household and workplace in 702 land was affected by HIV and affected by deaths and illness. So enormous gratitude for that, and then gratitude for the chance to be able to try to work at a difficult and interesting time in creating our democracy, to try to contribute to that as a judge, and to be present when some quite pivotal moments happened of importance to the judiciary and to our new democracy.
Absolutely. And in many ways, in the opening of your first book, Witness to AIDS, you speak about these parallel journeys of a judicial odyssey, but also a personal odyssey, living with HIV and AIDS, and publicly stating that. Take us through those two parallel journeys which have each had such a profound impact on the life of our nation.
Well, they've both come out this week, Sis, because I'm very happy that people have spoken about my judgments, about the decisions I contributed to, about the decisions I wrote. But at the same time, I'm a proudly gay man on a continent where we still have terrific homophobia and lesbophobia and violence against transgender people. In our country, we've got legal protection, but people are still at risk, many lesbians in townships. I'm also very pleased that people have spoken about HIV, because we have 7.5 million people in our country, over 2 million of them right here in Gauteng, many of them listening to us this morning, who are living with HIV or AIDS, and yet it's still this terrible disease of silence and stigma. So I was happy that all of those aspects were picked up in what was said about me this week.
You know, sometimes I think that the incredible work you've done and the amazing symbolism of your life as an openly gay man, as a public official until a few days ago, living with HIV and AIDS, dominates the conversation. And of course, one wouldn't want to detract from the incredible symbolic and work you've done in activism, but you're also a brilliant jurist, and you've made important contributions as a legal mind to our country. And it's that I really want to bring out today, because so much has been said about what you symbolize, but I think less has been said about what you have written and actually done for our democracy as a jurist and as a judicial mind.
The day job.
Indeed.
Yeah.
Indeed.
The day job for the last 25 years. Yes.
And, I think there's, many South Africans don't know what judges do. We know what sometimes you say, we know what you decide, but take us into the life of a constitutional court judge, particularly, in this last decade or so. What work have you been doing? What have your days looked like when you haven't been being exalted for some of your activism, but you've been doing the drudge work of putting our democracy together and guarding our constitution?
Well, Sis, that's a wonderful question. And the first thing I'd say is that it's a lot of grind, a lot of drudge work. You get to go into court and to read your judgment and newspapers and the public and your listeners get to comment on it. But preceding that, there's the enormous drudge work. The court in which I served for the last 10 years and 8 months, our country's apex court, has become enormously busy. When I started in the court in 2009, it had about 1/6 or 1/4 of the work it has now.
Sure.
So it's been an enormous increase, between 4- and 6-fold increase in number of applications, number of people who want to come to us, the number of cases we hear, the number of judgments we deliver. So first of all, it's just drudge work. And there I want to mention 2 things. The first is that we have the cleverest young South Africans. I don't know why on earth you didn't train as a lawyer and become a law clerk, because all the cleverest, most wondrous young South Africans try to get there, and we can take a small number of them. So we have really forward-looking, visionary, and I can't lose faith in our country when I see the quality of young people coming through in our court. So they help us with that. They arrange our applications, they do memos for us, they tell us what's next, they help with drafting some parts of memos, responses, even parts of judgment. Some of my law clerks have made significant contributions to my judgments, and I'm very proud of them for that. So it's a lot of drudge work. The other thing I'd like to say is that we're a court that sits en banc. That's a French phrase for saying we all sit together. We don't sit in panels. We're 11 judges of the court. The Constitution says that we have to sit as 8 in order to reach a decision. If we're only 7, we can't decide a matter. So we normally sit 11, quite a few times 10. Now that Deputy Chief Justice Zondo has been on his very important national work at the Zondo Commission, we've sat 10, and sometimes when the Chief Justice has had to be away, we've sat 9. One more than the constitutional quorum. But that means that we are chained together. I think of those southern American South chain gangs where people are chained together and sweating. And of course, it's an exaggerated metaphor, but we are chained together. Every single memo, every single application. Should we set this case down? How should we reply to this letter? What do we do with this new event in the case? Right, everything is decided collectively. So there's an enormous email traffic, an enormous traffic of memos, of opinions, of exchanges, and always, as you can imagine, because people are appointed to the court because they're experienced, because they've got strong views, because they've got strong commitments, you often have division. So tough, drudge, division, stress, but also right at the end, an enormous enrichment and enormous fulfillment.
I can only imagine, and I think that's a fascinating insight into the fact that at the Apex Court, nothing can be done without the other colleagues that you work with. And when I think of some of the issues that you have had to grapple with that have divided our country right down the middle, it must have been fractious at times when you, as judges, disagreed vehemently about matters that could fundamentally reshape the country.
Yeah.
And yet still had to come together and present a unified face in the end.
You know what I'm really glad about, Sis? This is going to sound paradoxical. I'm really glad that every tension in our country came right into the court. For example, racial and cultural tensions. We had the Pretoria street names case, where my colleague Johan Furneman and I, the two white judges on the court, dissented from our black majority colleagues. And there we were dealing with the same tensions, issues, different views of history that our people deal with. And we looked each other in the eye, we confronted our difference. It was a deep-going difference. It was not pleasant. And at the end of it, we realized that we retained our commitment to the same values, even when we differed on how to manage them. So that was, for me, a profound experience inside the court. It was the first time in the court's, at that point, 23-year history, that there'd actually been a division on the grounds of race on a racially loaded, culturally loaded matter. So I was glad that we did that and confronted it and survived it and grew stronger through it. And that gave me hope for every workplace, every home, every neighborhood, that we can do the same in our country. And I think that, I believe that a lot of racial confrontation, positive racial confrontation is happening. So we had that, and we had a number of difficult cases where we were simply unanimous. There were some cases, like with the Public Protectors and Kandla report, where we were profoundly unanimous from the start, where we realized that the Public Protector doesn't just give judgments in the air. It's not something for Parliament or the President or the Cabinet just to say, well, thank you very much, ma'am. Please sit down now. You've done your share. It has constitutional consequences. And we're still grappling with the consequences of our determination in that decision, which was about President Zuma's homestead and expenses on it. So it always differs. There's often division, but not more in our court than I would think in any corporate court. If you look at other apex courts in Western Europe, North America, and the rest of Africa, I don't think our rate of division and dissent is at all higher.
That's such a fascinating and, might I say, candid view, and really assists, I think, me in understanding what it must be like, you know, at the center of those moments before the cameras switch on. And the Chief Justice paid remarkable tribute to you in the final sitting at the court, saying how much he revered you, but also touching on this, your incredible calmness, your incredible ability for what he called anger management. And I'd actually like to play that now and just get your reaction to those heartfelt words.
I knew that I'd get whammied.
Well, you're being cross-examined. What can I say?
I'm delighted.
Edwin is not only a selfless person, he is also a humble person. And he is non-racialism epitomized. He is the epitome of non-racialism. I think you've got a much greater role to play in contributing towards the proper de-racialization of South Africa than you have. So we have enjoyed this man as our colleague. He has an amazing capacity for anger management. I've seen him provoked, and he is calm almost all the time. I think there's just one incident that almost escaped him, but he still managed it.
Between you and the Chief Justice, I'm snookered.
The floor is yours.
I'm not going to say what I think that incident was, because the Chief Justice didn't say what it was.
Okay, well, you know, I won't skewer you as you have skewered many before you.
But let me say this. We are in such a transition. We're a society of such extremities of dispossession. We're in a society with such a freighted history of racial subordination and indignity, and so, and injustice. And I think, especially those of us who are privileged, I think I'm privileged with my white skin. It's melanin deprived, but it's privilege enriched. I think that there is a call to restraint and humility because of many factors. But I'm making the call non-racially, because I think especially those of us in South Africa's, we're about 17 or 18% of us who are in the middle class. And I think there's a great call for us to be generous and to be restrained and to understand where we come from and to remember where we're going, which is we're the only society of our kind that has been confronting racial history in quite this way. It's not happening in America. Ask any Black American or African American. Ask any white American who's attuned to what's happening there. We are confronting issues in a unique way, and our eye is on the prize of not ignoring race and difference, but surmounting it in a way that is respectful and inclusive.
Absolutely. And what are your thoughts on how we do that? You know, just earlier this morning, the apartheid flag and the judgment over gratuitous displays of that flag has flared increasingly inflamed reactions. It does feel as though the tenor of our racial debate has changed tune recently. How should we be thinking through these questions as a society?
See, I'm one of those who believe that the most active people on social media are often the most angry. So I think that partly the manifestation of what has seemed like a more fractious, angry, hostile, divisive racial temperature is because of social media, or it's a phenomenon of social media. I see people getting on with each other, getting on with the hard, practical realities of life every day, and doing so in a supra-racial manner, not ignoring each other and their differences. So I'm not convinced by your implication that it's got worse. It may have. I don't always have my ear to the ground, but I think it's got to be done through candor and through humility and through confronting the differences.
And these are arguments you've made time and time again, that when we look at how fractious our society is, we often fail to appreciate some of the progress that we've made when we take a longer view, both even in cases of service delivery and questions of social unity. That's a deeply unpopular argument, but it's one that you've insisted on quite vehemently.
Yeah, I think so, Sis. I think there's no cause for complacency, self-satisfaction or self-congratulation on the part of government, the judiciary, any individual. But we have to see that we're not where we were 30 years ago, 25 years ago. Those who say that we haven't achieved anything are denying history. So we have to fight for a proper perspective in the light of history. We have achieved a lot. Racially, we are a society that is completely different from where we were 25 or 30 years ago. So that is progress. It's not progress to exult about. It's not progress to say, well, there we are, you know, we've got a majority black government. We've achieved victory over the past, because we haven't. The past is still with us. But we have to see that we're not that same society and that we have made huge strides forward. In electrification, go to the furthest corner of Venda. You'll see the houses electrified, water provision, kids at primary school. And in freedom of speech, which is one of my great joys, is how rude we are. I hope that some of your callers will phone in. You know,
Don't tempt them.
Well, I hope so. I hope that they'll scrub my ear and tick me off, because they're free to do so. They're not going to say, "Oh, it's Justice Edwin Cameron." They're going to say, "I've got a view, and I'm going to express it to him." And that is one of what we've fought for under apartheid. So we've got this. The wonders of our post-constitution society are not complete, they're not perfect, but some of them are there, and we should recognize them without denying them.
Absolutely. I want to come back to the story of your life as a judge now. And you served, of course, in the Supreme Court of Appeal prior to your ascension to the Constitutional Court. Take us through some of the differences between judicial life as an SCA judge and judicial life as a Constitutional Court judge from your perspective.
Well, it's fascinating that you ask that, Sis, because in the Supreme Court of Appeal, you sit in panels of 5. It's a very efficient court. It's our oldest appellate court. It was founded in 1910 when the 4 old colonies, colonial entities, were united into the Union of South Africa. And at that time, there were still votes for black people and colored people in the Cape. And that was one of the losses of unity, that in 1936, black people were deprived of the franchise in the Cape, and then in the 1950s in the Cape as well. But we had this court in its splendid building in Bloemfontein with a history and traditions, and that fine old courtroom in which Chief Justice Innes, Justice Schreiner, Chief Justice St. Livers gave wonderful liberal judgments, anti-racist judgments, pro-equality judgments that kept that flame of hope alive that the law could be something in democratic South Africa. So it was a privilege to sit there, much easier, very efficient court. You
Really?
sit down, you hear 5 of you, I believe it's become quite competitive. Some of my colleagues there give counsel a real roasting. I know that there's been a tradition of that in Bloemfontein. And then the judgment gets out quite quickly, 2 weeks. You know, you get a draft from your colleague, you say you differ, you go and sit down overnight, you write the dissent. The Constitutional Court is much more cumbersome because we're 11, because we're the apex court, because we've got help from law clerks. So it takes much longer. There are people who watch us, how long we take with our judgments. It varies. We aim to get them out within 3 months. We don't always manage that. Sometimes the judgment I gave on Tuesday morning in the Mulase case on labour tenants, we heard on the 23rd of May. So it was May, June, July, August, 3 months. It was just within 3 months. I thought it was 2 months. But so it's a court with strong traditions in Bloemfontein and strong traditions of scholarliness, of commercial expertise. We need more commercial expertise in the Constitutional Court.
That's something that's not necessarily a sexy legal topic, but maybe something that you've seen that isn't so much in the public debate.
Correct. And we are now the apex court since the 2012 amendment. We can hear all cases of arguable points of law of general public importance, not only constitutional questions. So we really need seasoned, experienced legal practitioners who've got their hands into the commercial practice of this country and abroad. So, and we haven't had that in this court because we were all appointed more for our constitutional expertise. So that was Bloemfontein. And then I came to the Constitutional Court, but the biggest difference was that I met law clerks. And as I've already given an encomium to the law clerks, it was the big difference. I learned to work very differently. I learned to think aloud, to dictate, to share my ideas, share the problems, and to get input twice a day from our law clerks. And that, I would say, with due respect to my wonderful colleagues over the last 10 years, the law clerks were the most delightful and enriching part of my Constitutional Court experience.
We're in conversation with judicial titan Justice Edwin Cameron, a man dearly beloved across our nation. We've been talking about his judicial career. His life is such an incredible life that in many ways, I don't think adequate focus has been dedicated to the judicial contributions that he has made. Fascinating stories about the SCA and the Constitutional Court. We're going to come back and ask some even more lit questions and corner him even further into spilling the tea. And before we do that, we're going to bring you the headlines. 25 minutes to 11, we're in conversation with a South African hero, Justice Edwin Cameron, in the first interview since he retired from the Constitutional Court. Follow the conversation on hashtag Sizwe with Justice Cameron. I see a number of your tweets, some people enjoying that you were cross-examined live on radio. Justice Cameron holds his fist up. We spoke a little bit about how the Constitutional Court is a body that is reliant on cooperation, maybe more than other courts. And I wanted to go into some of the big decisions that you had to make. I remember in your book, Justice, A Personal Account, which I think was written around 2013, or at least completed then. So much of what has happened at the Constitutional Court in your tenure actually has happened after that.
Correct.
I think of no judgment probably more profound than the Nkandla judgment, a unanimous judgment that really fundamentally reshaped our country. Questions of accountability and the role of the president. Can you take us behind the scenes as much as is possible about that seminal moment in our democracy and what it was like to be a Constitutional Court judge in that fundamental moment?
Sis, I think everyone in the court realized that we were confronting a constitutional crisis in our country. And that we had to match it with humility and with fidelity to the Constitution. That was the first issue. There wasn't any grandiose intervention. We had to look at what the constitutional text said and determine it. But the interesting thing was that if the Chief Justice had asked me to write that judgment, I think I would have fluffed it. I would have written a short judgment to say it is clear from Chapter 9 of the Constitution that the Public Protector has determinative powers. They're not just well-wishers. They're not just, yes, please, will you do this for me? They have bite. But the Chief Justice saw, and this was the depth of his stature and understanding of what South Africa required at that moment, was that the whole country was yearning to hear about political and public accountability. The country was yearning to hear a figure of unimpeachable integrity talk about integrity and non-corruption and commitment to social justice and to the ideals of the Constitution. So the judgment the Chief Justice wrote is I think, an international classic, because it does the job that I would have done, which is to look at the Constitution, to look at the precedents, to look at the preceding judgment by Judge Mohammed Nafsa, Deputy President Mohammed Nafsa in the Appeal Court, which the previous year had decided very much the same issue. But this time it wasn't the SABC, it wasn't the Motsoeneng issue before us. This time it was the President of the Republic. So a very dramatic moment, one I think that the court met through the stature and the insight of the Chief Justice. And if you're going to tempt me to say, do you mean insight as a preacher? I'm going to say, Sizwe, stop being provocative.
Well, you said it, not me. And that's... What did it feel like after that judgment? Because it had such a profound effect on our country. Did you get a sense of the power of the court maybe in a deeper way than you had previously?
I would say the stature of the court, because the court has power, but you can misuse power and be ignored. But I thought that the stature of the court was increased by that. And then, of course, we gave 3 more judgments about the secret vote. We gave judgments the final of the 4 important judgments was the one about impeachment, which was where we said that the Parliament has to have a process in which a president accused of serious contraventions and misdemeanors and crimes has got to be confronted in the process. It's not just a vote. And that was a very important judgment. That judgment was handed down in December 2017, 6 weeks before President Zuma resigned. So we had a sense, to answer your question, we had a sense of the court's stature. It wasn't just that it was a technical, grinding grey court that was bean counting and saying this is where the case comes out. It was a court that had a sense of our history, a sense of our Constitution, a sense of our people's needs, but all of those things with a very present humility as well.
And I think history will determine your judicial legacy, which I think will be dazzling, but I think one of the key foundations of that legacy will be the work you've done around holding power accountable. And of course, in later moments in the Constitutional Court, you've reflected on that. But one of the key moments, I would venture, in your judicial career was also the Glenister judgment, written alongside, in many ways, Deputy Chief Justice at the time, Dikgang Moseneke, a crucial moment in which you made an intervention about how power is held accountable in this country, and who would know how important that question would be in the years and perhaps decades which will follow.
I think you're right to raise that. Deputy Chief Justice Dikgang Moseneke was the lead author of the judgment. It's his and my judgments, and he was the primary author. Yes, definitely. And he's a man of considerable stature and experience and of literary, as you know from his book, and there's another one coming. So he was definitely the lead author. See, what we did there, it was a crisis post-Polokwane. We have Polokwane at the end of 2017. We have the removal of President Mbeki in September 2007. President Mbeki goes in September 2008, and then we have the election coming up. And the first thing that happens is that the Scorpions are abolished, this independent corruption-busting unit. And Mr. Glenister, a lone maverick with, thank goodness, a pocket to fund legal expenses, says, but you can't just abolish the Scorpions and put a toothless watchdog subject to the National Commission of Police in its place. He brings the argument to court, and it looks hopeless. And the Helen Suzman Foundation briefed independent counsel, Advocate Unterholt, who's now a judge in the High Court, and Advocate Max du Plessis, and they brought an argument that South Africa signed anti-corruption conventions, not just United Nations conventions, not just Africa Union conventions, but SADC conventions. All those conventions say you've got to have a sufficiently independent anti-corruption unit. What we did in that judgment was to say, we've signed all those treaties, get real, do something about it. They're not just, yes, please, out there in the international law stratosphere. They take bite right here at home. That was the importance of the judgment.
About to hit 11:15, we're in conversation with recently retired Constitutional Court Justice for the first time since his retirement, Edwin Cameron. Stay tuned. What an incredible conversation so far with recently retired Judge of the Constitutional Court, Edwin Cameron. Keep following on social media on the hashtag Sizwe with Justice Cameron. And we're going to go to your calls now. I know you've been waiting to engage with Justice Cameron. Celeste, welcome to the show.
Good morning, Sizwe and Edwin Cameron. This is the most beautiful conversation. I've thought about things while I've been waiting on the phone to have a little high. We have come such a long way since 1990, but there are still so many issues and so much inequality. However, without people like Judge Cameron over the years making such an impact, I don't know where we would be today. So I would like to just say thank you, and we salute you, and all the absolute very best for the future.
Thank you so much, Celeste, for that tribute. Cynthia, we're going to come to you as well. Hi, Cynthia.
Hello. Okay. Hi. Thank you for taking my call. Judge Cameron, you are a mighty warrior for justice in South Africa. Now, I proceed on to what I actually phoned about, and that is, I am so grateful that you came on and spoke the things that needed to be spoken about this nation. And that is, there's a lot of corruption. Everybody knows. There has been, and there probably is going on, but not as much as it used to. But the thing that bothers me is the negativity, the way we focus on the things that haven't been done yet by this government. You know, I've always, in fact, when we started off, I voted the ANC, but now I'm voting opposition, not because I hate the ANC, but because I want us to have a strong democracy. That's why I'm voting opposition. But there must be, truth has to be said, that a lot of good has been done. Somebody phoned this morning and said, this government has done nothing. I think, Sizwe, with all love to you, but you should have corrected her and educated her and showed her that a lot has been done. Okay, and the last point now is, I think the radio presenters should try to be as neutral as possible, because your platform is very powerful. You can actually destroy a nation with your words on the radio. Imagine, you know, actually it makes me think of people like Judicial. Cynthia,
I'm going to have to ask you to just round up on this thought.
Yeah, I'm finishing. When she left the station, I couldn't guess what party she was voting for, because she was so neutral, she was so fair, she was so professional. We need that back in 702, please.
Thank you very much, Cynthia. We appreciate your calls. Justice Cameron, your response to the callers.
Well, I'm grateful to both Celeste and Cynthia, and I want to pick up something that Cynthia said that I think is very important about corruption, and it shows the limits of what the courts can do. We said to Parliament in the Glenister judgment in April 2011, set up a proper independent corruption-busting unit. They said they did so, but they didn't. It came back to us in the second Glenister, the third Glenister case. Helen Suzman Foundation brought it back again. So we then again had to say to them, this legislation is not good enough. And then they appointed someone whom the courts eventually removed as head of the Hawks. So the courts can only do so much, Susan. That's an important thing, which brings me back to Cynthia and to Celeste, which is that Cynthia says, I've exercised my right to change my vote. My heart thrills to that. Call me a sentimental old man, but I love it. I love it, sees that we have got a democracy in which people, a more outspoken democracy than anywhere on this continent, than anywhere through most of Asia, including, regrettably now, India, through large swathes of the rest of the world. So we have that, and the closing point I want to make is that the courts cannot remedy what government doesn't do. It's up to people through their holding public representatives accountable, joining independent organizations, exercising their vote, claiming this democracy and this constitution for themselves.
Absolutely. And, you know, I wanted to ask you in terms of that, because we focused on an aspect of your legacy that I think has been crucial, but maybe not connected with your name so much, about accountability. But, you know, just like authors, I suspect that judges often write judgments that are their favorites, but that don't get public admiration. Is there any aspect of your judicial legacy that you are particularly proud of that perhaps hasn't got the public attention that you believe it deserves, like the high-profile cases you've been a part of?
Well, that's a lovely question, Cies. Let me answer it a bit obliquely. You know, my colleague Justice Sisi Kampepe joined the court at the end of 2009, and quite shortly afterwards she gave a momentous judgment, and I'm very proud of that judgment. It's an undersung judgment. It's the judgment in Mankai. It's the judgment that said that mine workers who are disabled by lung diseases are entitled to much more compensation. They're not limited by the statutory wording to derisory compensation. We had people who spent decades in the mines, went home to the Eastern Cape or to Lesotho or to Mozambique to die. And that led to a dramatic process that is culminating now, where the mining companies, I think very rightly, set aside a huge fund, not enough, but a huge fund to compensate people. So I think my colleague Justice Kampepe's judgment in Mankai, she's an important figure in our court. I mentioned her in the proceedings on Tuesday morning. I teased her a bit about her Zulu heritage. And I think Mankai, I'm proud of Mankai because we all participate in each other's judgments. I felt very keenly. I'd worked for the National Union of Mine Workers. I'd been down to the bottom of a gold mine, down to the bottom of a coal mine in my job as advocate. So I felt very passionately about this. So I think that's an undersung judgment. And I'm proud that I fought for it. I'm proud that I contributed to it. And I'm proud that my colleague Justice Kampepe wrote the judgment.
Fascinating stuff. I also wanted to ask you a question that I know is hard to answer. And maybe there's not one moment, there are many. But what springs to mind as the hardest moment in your judicial life?
Oi. 25 years. You know, there are two cases that linger in my mind, Cies. In my first term, sitting as a criminal judge in 1995 in Springs, there was a murder in an informal settlement, and the investigating officer was an impressive man who'd had a lot of experience, an impressive black man, which is relevant because this was 95, just after the transition, who was a warrant officer in the SAP previously. And he gave very good evidence. He'd collated the evidence, and I convicted 4 or 5 youngsters, just over 18, in their late teens and early 20s. And I remember when I read the judgment, one of them looked at me in disbelief and almost pity. I've never forgotten that. His look was saying to me, "You've been taken in by this guy." And that has stayed with me. I've often wondered, was I taken in by that proficient investigating officer? The other moment was on the Constitutional Court. You know, says, I want to mention someone, and I hope your listeners are going to get their ears tuned, because this is going to be controversial.
Oh, my.
She was a splendid woman called Captain Barnard. And she was recommended for promotion to a wonderful job at police headquarters, liaising with the public and with other sections of the police by 2 committees which were black committees, senior committees of regional commissioners and generals and brigadiers, who said Captain Barnard is the best. And twice, Commissioner Jackie Salibi said, "I'm not going to appoint her because she's white. We need another black person at police HQ in this particular slot." Now, her advocate didn't challenge the targets under which Police Commissioner Jackie Salibi refused to accept the recommendation of these two-time committees. I look back, and Captain Barnard left the police. I think, sees that maybe the law let her down, maybe we let her down. I regret the fact that the police, that public service, she was a committed person, committed to transformation, an Afrikaans-speaking woman, every inch of her committed to the future of our country, and somehow we didn't do her justice. That stays with me, and I hope I get burnt for saying that. You asked me about my conscience, and I've given a truthful answer.
Well, it's, I mean, just incredible, both of those cases, and what it makes me realize is that one of the hardest things about being a judge must be when a broader systemic problem is going one way in society, but the facts of a case happen to cut across that, and one has to make an unpopular decision nonetheless,
exactly.
or come to an unpopular conclusion.
That's why I'm so sorry that you lost to the legal profession. You've summed up exactly the institutional, the institutional issues, the public issues, the mass issues, and sometimes they run up against the individual justice issues. They shouldn't. They did all the time under apartheid. Some judges said, oh, well, I'm very sorry about this law. And we said, that the critics of the apartheid judges said, do better, try better. And that's the agony, that sometimes as a judge you have to wrestle with, are you looking at the broad sweep of the law and your duty, and are you looking sufficiently to what the justice of the individual case requires?
Absolutely. I mean, right now, the judiciary is under a lot of pressure. Maybe it's just angry people on social media, but a new argument, which I suppose has popped up from time and time again, is suggesting that there's corruption in the judiciary, that the judiciary is not as impartial as it should be. The public protector, even yesterday, taking to TV screens and saying that further investigations need to happen. What's your view on the judiciary, and what's your response to some of the direct attacks on the judiciary as an institution, not simply judicial decisions?
Yes. Sees, I think it's good that the judiciary is open to scrutiny. It must be accountable. It's publicly accountable. It should be. I think some of those attacks might be political opportunism. I don't know. I've been so busy with other things that I would reflect on them. I'm not evading the question. I think some of the attacks are probably politically opportunistic and individually opportunistic. I don't doubt, speaking from every single judge that I've worked with over the last 25 years, and speaking for every single one of my colleagues, some of whom I've differed from very deeply and sometimes bitterly, I have no doubt that their commitment is to their judicial oath. There have been a few people about whom issues of integrity have been raised. I know that in the challenge to Judge William Suriti's Arms Deal Commission, a very impressive bench of 3 judges present. I think it was Judge President Monica Liu, Judge President Dunstan Mlamba, and Judge President Dennis Davis, who gave this very important judgment, which implicates one of my colleagues in a question of possible integrity. I haven't read the judgment yet. I'll go and assess it for that. But I can say that overwhelmingly, every judge that I've encountered, with very, very few exceptions, have unimpeachable integrity. They are not driven by partisan notions or we'll get this person here. Not at all. We have a bigger project, and the project is social justice, human dignity and equality under this wonderful constitution. That's what we take the oath to observe, and that's what I believe the 240 judges of this country are genuinely committed to.
I have an inkling that we have not seen the final public acts of Justice Edwin Cameron. The Chief Justice had the temerity to suggest to Minister Lamola that he realized there was a vacancy in the inspector for prisons. What might we expect in the next chapter of the life of Justice Cameron?
Well, we'll see, Sis. I did start, as the Chief Justice said, the prison visits program at the court. We hoped that it would spread through the judiciary through our example of going into prisons and writing reports and helping the inspectorate. Should something, I don't know that there is one. In fact, the Chief Justice was reaching out to give me a shout out there. We'll see what happens, and perhaps there is a role, perhaps there isn't, but we'll see what happens.
How will you rest after this period of 25 years of intense concentration?
Well, I hope to be doing different things, sometimes slightly more restful things, but also not resting all the time.
Well, I've said that I hope that there are more opportunities for Godfatherly tea opening on the horizon.
Daily.
It's been a tremendous honor for me to conduct this first interview with you since your retirement, and personally thank you not only for your contribution to my life, which beyond my parents is the signal contribution, but more importantly, your contribution to our country. You are a true South African hero.
Thank you, Sizwe.
Thanks for watching the content. Like, share and subscribe on all platforms, smwx.co.za to join the WhatsApp channel. And let's build a new conversation for a new generation. Ayeye.